The Superior Court of the Provinces, the Federal Court, and the Supreme Court of Canada all have a power that has been in operation long before Canada became a Dominion. Prior to the courts being created in Canada, there were courts present in Britain, England, and so forth. These courts had the ability to deal with common law problems, and this historic power to deal with common law rights has been transferred into the Superior Courts, the Federal Court, and the Supreme Court of Canada. When we look into the Ontario Court of Justice Act, Article 11.2, we find the following statement. The Superior Court of Justice has all the jurisdiction, power, and authority historically exercised by courts of common law and equity in England and Ontario. Vincent versus Ottawa, Ontario Superior Court Judgment. The Superior Court of Justice has all the jurisdiction, power, and authority historically exercised by courts of common law and equity. The power that operates in the Superior Court is a power that has been present within the societies of men for many, many centuries. It is not a power that was created by the government, but a power that operates against the government. This power is designated the inherent jurisdiction, inherent power. It has one purpose and reason for being present, and that is to protect our fundamental rights and freedoms. When you look into a court judgment, Scorola versus Minister of National Revenue, it says the term inherent jurisdiction is one that is commonly and not always accurately used when arguments are made with respect to jurisdictional basis upon which a court is asked to make a particular order. The inherent jurisdiction of a superior court is derived not from any statute or rule of law, but from the very nature of the court as a superior court. Superior courts have inherent jurisdiction. This does not come from statutes or regulations, but from the very nature of the court. Superior courts have common law power. This is historic powers that were in operation before the Dominion of Canada. When we look into the description of the superior courts of the province, we find exactly what we should expect to find if we know what we are looking for. There is a power that operates in these courts that is present to enforce common law rights. This power is not in the court because of statutes and regulations. Common law rights now flow through the Constitution Act of 1982, and a violation of our common law rights is a violation of our charter rights, and in turn, a violation of our international human rights and freedoms. The courts here in Canada, and more specifically, the Supreme Court of Canada, the Superior Court, and the Federal Court of Canada, they exercise something that's called historic power. And this historic power is defined for us as common law rights that were in operation and existed in England and Great Britain prior to Canada being a dominion. This historic power was transferred into the courts of Canada, and it says that this historic power, it has all the jurisdiction and all the powers, all the abilities that were being exercised in these common law courts back before Canada was a dominion. Now, this historic power that deals with the ability to enforce common law rights, which we now know are human rights and fundamental freedoms, do not come from statutory powers. They are not created by enactments and regulations and given to the courts. They exist prior to enactments and regulations. The courts are exercising something that's called historic powers. And we understand that that means the inherent jurisdiction of the court itself. And these historic powers, the inherent jurisdiction of the court, is there to enforce our common law rights. We learned in the past two videos that these common law rights, they were grandfathered in from Great Britain. They flowed through the Bill of Rights in 1916. They became foundational law through the Charter of Rights and Freedoms, the Constitution Act of Canada 1982. Now, common law rights are now expressed in 2017 as fundamental human rights and freedoms. So this means that the courts, they have the jurisdiction and the power to deal with these situations, to deal with the limitation or abridgment of our fundamental rights and freedoms. The only difference is that we take off here common law rights, because now we understand it flows through the Charter, through international law. So the courts, they operate historic powers. This is the inherent jurisdiction of the court. It's there to enforce our fundamental human rights and freedoms, and it has all the jurisdiction and power that it needs in order to produce a remedy on our behalf.
The Supreme Court has made it clear, in cases M.A. versus Ryan, that the common law must develop in accordance with Charter values. A trespass in common law equals an infringement or denial of a fundamental right or freedom. Again, when we look into DeVito versus Canada, Supreme Court of Canada, it states that Canada's international obligations and relevant principles of international law are also instructive in defining the rights. The content of Canada's international human rights obligation is, in my view, an important indicia of the meaning of the full benefit of the Charter's protection. I believe that the Charter should generally be presumed to provide protection at least as great as that afforded by the similar provisions in international human rights documents which Canada has ratified. Inherent jurisdiction is there to enforce common law rights. Common law now flows through the Charter and flows through international covenants. Inherent jurisdiction to enforce human rights and freedoms under the administration of justice. The attributes of the superior courts concerning the inherent powers are brought forth to us as follows. The inherent jurisdiction of the court exists long before the Dominion of Canada. Its historically exercised power. The inherent jurisdiction of a superior court is not derived from any statute or rule of law, but from the very nature of the court itself. The court has all the jurisdiction, power, and authority historically exercised by courts of common law. When you have a foundation, understanding inside concerning your fundamental rights and freedoms, you can begin to see and understand what is transpiring with the courts and its inherent powers. As individual men and women, we have natural rights and freedoms, which are common law rights, and in 2017 they're better known as human rights and freedoms. These rights and freedoms that we have existed long before Canada was a dominion. Our fundamental rights and freedoms were not given to us by any statute or regulation. Thompson Newspaper Limited versus Canada. While individuals, as a rule, have full legal capacity by operation of law alone, artificial persons, classes of beings, are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. The individual may stand upon his constitutional rights. He owes no duty to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land long before the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. Individuals have full legal capacity, common law rights, natural rights, human rights, and freedoms. These rights do not come from statute or regulation, and they existed long before the Dominion of Canada. The description of our full legal capacity brings out the same qualities and attributes as we have found operating in the inherent power of the Superior Court. This is because the inherent side or power of the Superior Court is there for one thing, and one thing alone, which is the administration of justice, upholding charter rights. The individual has rights and freedoms, power, not given to him or her from statutes or regulations. Remember, the court judgment said, while individuals, as a rule, have full legal capacity by operation of law alone, artificial creatures of the state
and they enjoy civil rights and powers only upon the approval of statutory authorities. The court has powers, right to deal with common law breaches, and these powers are not given to the court through the enactments and regulations. So you're seeing the similarity. As men and women, our full legal capacity flows from the law of the land, flows through common law, flows through our fundamental rights and freedoms, and they do not exist because of statutory power. While the inherent power of the court is the same thing. It operates exterior to statutes and regulations. The court, it operates inherent jurisdiction. It operates all the power and jurisdiction to enforce common law rights, which we now know are human rights and fundamental freedoms. Now, this power, this inherent jurisdiction, it existed prior to Canada becoming a dominion. It was transferred into domestic law. And this inherent jurisdiction, this power, does not come from enactments or regulations, does not come from statutory power. So when you look to the individual, when you look to a man or a woman, you find the exact same nature. What is it? Individuals, men and women, we have fundamental human rights and freedoms. They existed prior to Canada becoming a dominion. And these fundamental rights and freedoms do not depend on statutory powers, enactments and regulations for their operation. So we see that the court and our fundamental rights and freedoms, the nature of the rights and the court are the same. Same operations of law going on. Court inherited its powers from Great Britain and England to deal with the common law. However, since the covenants, common law has been transferred into our human rights and fundamental freedoms. Individuals, our rights and freedoms, our human rights and freedoms were grandfathered in from Great Britain and England. It flowed through the common law, flowed into the Bill of Rights, now rests, and we can find them in the Constitution Act of Canada 1982 and the international covenants. These rights were not created by statutory powers.
Scarola versus the Minister of National Revenue, 2002. The inherent jurisdiction of a superior court is derived not from any statute or rules of law, but from the very nature of the court. So an individual has full legal capacity, and this full legal capacity does not come from statutes or enactments. The inherent jurisdiction of the superior court does not come from statutes or enactments. The natural, fundamental rights and freedoms of a man or a woman exist and operate long before the creation of the Dominion of Canada. Remember, his rights are such as existed by the law of the land long before the organization of the state. The inherent power of the superior court that is now used to uphold charter rights and freedoms has existed long before Canada was a dominion. Remember, exists long before the Dominion of Canada. These powers were historically exercised. So the superior court, through its inherent power, has all the jurisdiction, power, and authority historically exercised by courts of common law. Our full legal capacity, our natural rights existed long before the creation of the dominion called Canada. The inherent powers of the court existed long before Canada was a dominion. The inherent powers of the court are historic in nature. We can clearly see the reason why there is inherent power in the superior court. These powers are there strictly to enforce our rights and freedoms, and can be accessed by those who understand what is transpiring in the court system. This inherent power is not used for anything else but to produce a remedy concerning the administration of justice, to produce a remedy for denial or limitation of our charter rights and freedoms. The superior court also operates under statutory power, under enactments and regulations. And when the court is operating under enactments and regulations, it is a statutory creature. And they are dealing with statutory creatures, drivers, students, taxpayers, etc. So there's two sides to a court. One is the inherent jurisdiction, and one is the statutory side. The powers it can exercise and the duties it has as a statutory court all come from the enactments and regulations.
When the court is in its statutory form, it does not possess the inherent power, and neither can the court operate this inherent power. And this is a very important distinction and very important operation of law to take note of and to remember. Now, Scarola versus the Minister of National Revenue, 2002. The court, as a statutory creation, does not have the inherent jurisdiction. Superior Court, inherent jurisdiction, inherent power, comes not from statute. It's there for the administration of justice, to uphold charter rights. Superior Court, as a statutory court, has no inherent power. When you are brought into court, and the other party is claiming that you have violated an enactment or regulation or a bylaw, it is into a statutory court that you will be brought into, and this court will try to rule over you through the obligations of the enactments. Remember, they are incorporating you into their corporate body, and then, as a class of person, as a statutory creature, they claim you owe an obligation to the statutory instruments. This legal ground can easily be defeated when it is brought forth into the inherent side of the court. The superior courts can exercise jurisdiction in two capacities. They can operate the court as a statutory creature, enforcing and operating strictly from enactments, or the court can exercise the inherent jurisdiction, strictly enforcing and protecting charter rights, the administration of justice. In Michie Estate and City of Toronto, at page 215 and 216, Stark J., after considering the relevant provisions of the Judiciaire Act and the authorities, said, "It appears clear that the Supreme Court, i.e. the Superior Court for provincial, has broad universal jurisdiction over all matters of substantive law. Unless the legislator divests from this universal jurisdiction by legislation in an unequivocal term, the rule of law relating to the jurisdiction of a superior court was laid down at least as early as 1667 in the case of Peacock versus Bell and Kendall. And the rule for jurisdiction is that nothing, you see that, nothing shall be intended to be out of the jurisdiction of a superior court. How? Through its inherent power. The superior court has inherent jurisdiction. It's for the administration of justice. And now it's there to uphold our charter rights and freedoms. Now this inherent jurisdiction, this power, this rule that says the superior court can take jurisdiction over any matter has been in operation since at least 1667. When it comes to enforcing our fundamental rights and freedoms, the superior court of our province has the ability to provide a remedy for us through the inherent jurisdiction. When our charter rights and freedoms have been denied or infringed, then the inherent power of the court is there for us to access and obtain remedy against the violations. If a right exists under common law, which is now in the Charter, which is an expression of international law, the right itself gives power to the court to deal with the violation. In Board versus Board, we saw the following. If the right exists, the presumption is that there is a court which can enforce it. For, if no other mode of enforcing is prescribed, that alone is sufficient to give jurisdiction to the King's Court of Justice. In order to oust or remove jurisdiction, it is necessary, in the absence of a special law excluding it altogether, to plead that the jurisdiction exists in some other court. The Superior Court is considered the King's Court of Justice. In 2017, it is now Her Majesty's Court of Justice, but it is the same operation of law. The Superior Court has all the jurisdiction, power, and authority historically exercised by the courts of common law, which used to be called the King's Court. Now remember, when we're talking about the Superior Court, we're also talking about the Supreme Court of Canada, and if you look into the enactment, you'll see that the Federal Court of Canada has been given original concurrent jurisdiction. So it has inherent powers also. Now, Vincent versus Ottawa. The Charter, therefore, does not bestow upon the court jurisdiction it previously lacked. It does, however, grant rights not previously enshrined, which may be enforced by the courts of competent jurisdiction having powers acquired independent of the charter. So this guy is saying a lot in that one little statement. So we are seeing that the courts, they can operate under two distinct jurisdictions, and two jurisdictions alone. They can operate as a statutory court, or they can operate under the inherent power of the court. As a statutory court, it's there to enforce the laws against statutory creatures. It's there to enforce the enactments and regulations, the duties and obligations to these statutory powers. And when the court is functioning as a statutory court, it cannot access the inherent jurisdiction that is in the court, that resides within the court. So for example, you walk in there, whatever the matter may be, and you understand that they're calling you into that court as a class of being, as a class of person, the driver, the taxpayer, the homeowner, whatever it may be, and you're walking into a statutory court, and then you want to start to try and access the inherent power of the court. We're seeing that they've already ruled that it's impossible. You can't do this. There's no way to make the connection. If you're there under statutory court and they've brought you as a class of person, then they're only going to be there to try and enforce the statutory power. Now, there has been some changes here in Canada in the past 2 years, only dealing with traffic court, because of what's been transpiring with individuals seeking after their fundamental rights and freedoms. And I brought this forth in other videos already present on YouTube on my channel, so I'm not going to really get deeply into this. But they have created some enactments and regulations which change some of the traffic courts that are in our provinces away from statutory power and granted them a little bit of inherent power. So for those individuals who are going in there and claiming, listen, I wasn't operating under statutory power, I wasn't partaking in commerce, I wasn't transporting goods or passengers, no one was paying me, I wasn't employed, and that's the basis of that argument. The court has been granted certain powers to say, okay, we're not going to strip you of your fundamental right and freedom in this certain aspect. And they got that through the enactment. But apart from that, apart from what they've done to the court recently, majority of statutory courts, they do not have inherent powers. And you cannot access the inherent powers of the court because you're there as a statutory creature. So what happens? So before you get into court here as a statutory creature, you got to somehow intervene. You got to somehow stop this process and then get into the inherent jurisdiction or the inherent power of the court. And that's where your challenge comes in. So when you access the inherent power of the court, it's there for the administration of justice. It's there to enforce your common law rights, your fundamental rights and freedoms, and to produce a remedy for you. So you go to court, you're called in, and you say, well, I'm not that person, I'm not that artificial being, and you don't have the right to judge against me. None of that's going to work. Maybe what you are declaring is true, maybe you're not bringing it forth through the proper principles of fundamental justice, showing how they're denying and limiting your rights, but what you're stating is true, absolutely. You're not a class of being, you're a man or a woman with full legal capacity with all your fundamental human rights and freedoms, but they're not going to hear that in the statutory court. The only thing they're going to hear is that you are a limited being, given certain rights and freedoms, you are a statutory creature, a class of persons, and you owe the duty to the enactments and regulations. And you can argue till you're blue in the face, yeah, but I have this right, and I have that right, and I have this freedom and that freedom. And you could even express your principles properly while you're talking in this way to this court. But guess what? It's not going to change the power of the court. It's not going to get that judge or that court to produce a remedy on your behalf. Why? Because he doesn't have the power. He doesn't have the ability. Even though he may be sitting there and understand what you say and understand the operations of law and agree with you that you have been limited and abridged in your right, he cannot cross over here into inherent jurisdiction to produce a remedy for you. Because you're stuck in a statutory court. And a statutory court cannot access the administration of justice, the inherent power to do that. So again, You have to intercept them, and that's where your challenge comes in. So if it's a criminal trial, if it's under the criminal code, they call that a pre-trial. And I've shown in my other videos that if it's criminal code, you deal with that in the pre-trial. You deal with all the situation here in the pre-trial so they don't send you to trial. You find out what they're charging you under the enactment and regulation, what class of being it is, how is the enactment limiting or abridging your charter right, your international right, your fundamental human right and freedom, and then you bring that to the court in order to put a stop to that. In other ways, if it's civil problems, you can't do it. You can't do it with a pretrial. You have to know what forms to use. You have to know what operations of law to call upon. No matter what province you are in, if you go and search the Court Justice Acts and look at their forms, you're going to find forms that deal with constitutional challenges. You're going to find forms that deal with issues concerning the charter rights and freedoms, of violation against your charter rights and freedoms. These are the particular court forms that need to be used in order for you to have access to the inherent power of the court. Now within that form, remember, within my past two videos that I've been showing you, you have to bring forth the principles of justice. You have to say, okay, here I am as a man, and I have a fundamental right and freedom. It's recognized, granted, preserved, insured, protected for me in international law. No limitation, no abridgment can be placed upon this right. It's been transferred into the Canadian law through the Charter of Rights and Freedoms, through the Constitution Act of 1982. I still had my right. Now the legislator created an enactment, created a statutory power, created a law that limited and abridged that right of mine. And you have to explain that and bring it forth to the court and show what's transpiring and then ask or demand for a remedy. But it's absolutely necessary, and you must access the inherent power of the court. Because if you're sitting in the statutory power, and whether you express this all correct, and you have all your if they say buttons in a row there, it doesn't matter. The judge can't take his gavel and say remedy produced on your behalf. He doesn't have the power. He's in a statutory court. He's limited himself. He doesn't have the ability to say, yes, here's your remedy. So what the Canadian court system has done is they've made it hard to find out how to move between these courts. They always call us in to the statutory side. So right away when they call you in, you're a statutory creature, you're a class of being, you owe the obligation to the enactment and regulation, and now we're here to punish you and enforce that enactment and regulation against you as that class of being. That you're aware of. But what we don't understand is, okay, well, what is the mode of operation? What is the mechanism that's available for me to stop being called into court as that statutory creature and to access my fundamental rights and freedoms before the court system? And they did it, like I said, through those specific forms. So whether you're going to tax court, for example, if you've been called into tax court of Canada, there's a form in there. It's called a constitutional challenge. If I'm correct, I think it's number 64 is that form. And with that form, you're allowed to go before the court and you're allowed to invoke your fundamental rights and freedoms and challenge them and say, hey, well, listen, you've got an income tax enactment here that's rendering me an officer operating from an office of Canada. It's saying that I'm resident within the corporate body of Canada and therefore I'm subjected to pay a taxation upon public money that I receive. Further to that, in Ontario, just use that as an example, the Business Corporations Enactment, it forces me to take recognition as that class of being of a director, which then further forces me in the Income Tax Enactment to be indeed operating from an office as an officer of Canada, because anybody who's been designated a director of a company through the Income Tax Enactment is automatically forced into the role of playing officer of Canada, operating an office of Canada. And then if you go to work, and if you're hired for an employment, then they're saying that you're appointed into this position. If you're a cook at McDonald's, if you're a real estate agent, if you're a construction site worker, no matter where it may be, they're claiming that that job that you got, you were appointed in position. And then again, you jump into the Income Tax Enactment and it says anybody who's been appointed into a position is automatically operating as an officer of Canada. So they got it all set up for you to be that class of being. They have it all set up for you to operate from that statutory power in every action that you do. But on the flip side of that, there is the inherent powers of the court. There is the administration of justice that an individual can seek, but it's a narrow road. It's such a small, tiny road. The statutory court, it's broad and wide, right?
You're a driver, you're a student, you're a taxpayer, you're a homeowner, you're a consumer, you're a patient, you're a criminal. Very, 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 very many roads, very, very many designations. But when it comes to the enforcement of our fundamental rights and freedoms, it's one little avenue they preserved for us, which is find those proper forms, bring out the principles of fundamental justice, show how the enactment is limiting and abridging your fundamental rights and freedoms, notify the Attorney General at least 14 or 20 days to be safe here before you go to court, and then when you walk into court, no longer will you be walking into a statutory court that's there to say, hey, you're a class of being that owes duties here to the body corporate. You'll be walking into a court of inherent power. Now, that doesn't guarantee you're going to get your remedy, because you filed the proper forms, because you did everything properly to change the face of the court into the inherent power of the court. It doesn't mean when you get there right away, the judge is going to say, hey, great, what's your remedy? Remember, I shared with you that judge, even in the inherent power side of the court, what's he's under the presumption of? He's under the presumption that what you're complaining about, this enactment and regulation, it conforms to international law and it respects the Charter. And he's under that presumption because the Attorney General of Canada, or the Office of the Attorney General of Canada, placed him under that presumption by signing off on the enactment and saying this enactment respects everyone's fundamental rights and freedoms. So you're walking into a court of inherent jurisdiction, of inherent power, with a judge that's sitting there that's saying, hey, I'm under the presumption that what you're claiming is garbage, and what you're trying to tell to me is garbage. That enactment, according to the Attorney General, it respects fundamental rights and freedoms. So now what do we have to do? We have to say, okay, here's my right, judge, and here's the principles of fundamental justice that govern that right in this particular area. We know that the principles of fundamental justice do not operate the same per right. Each right has a set of principles of justice that governs it. If you're a voter, for example, like I said, you have the right to partake in the government, you have the right to vote, but that right can be limited or abridged in a time of war or emergency. Well, you have other rights that can be never limited or abridged, and that's the principle that you got to bring forth before the judge and show him, this is my right in my full legal capacity, this is how it operates, and this is what the enactment has done to me. It removed that right from me. It limited and abridged that right from me. And then when you do that, in the inherent jurisdiction of that court, then he can produce the remedy on your behalf. Now, they don't want you to know all this. They want you to stay stuck here through all this, and bang, bang, fine you, and bang, bang, put penalties on you, and you better obey what we're telling you. But if you can never understand what's transpiring, that there's a whole set, if you will say, of rights and freedoms that are in operation that we can access, then you can protect yourself. And I'm going to say it one more time because I see it time and time again as I sometimes search videos on YouTube and look at what people are teaching. They're telling you, hey, go into the statutory court, bring your birth certificate, say, here's the artificial person that you're looking for, I'm not him. Go into the statutory court and tell them you have rights and freedoms and that they're violating your common law rights. That's not going to work. You got to understand that's never going to work. The judge can't even, he can listen and hear you, but he can't hear you in law to say, here's a remedy on your behalf for what they're doing. He may even agree that what the state party is doing is wrong, and he may even understand that they are limiting and abridging your fundamental rights and freedoms, but he doesn't have the power. And if you don't have the power, no matter what you do, you just don't have the power. So when you intercept them and you stop from going into statutory court, different story. Now the judge has the power. He has the ability to enforce common law rights. These common law rights flow through human rights and fundamental freedoms. Now it's up to us to prove that there's been a limitation or abridgment of our fundamental right and freedom.
Superior Court, it did indeed have inherent power prior to the Charter. And prior to the Charter, it was present in the court, but hard to access. Now, the Charter did not give inherent powers to the courts, but granted us protection, me and you, as individual men and women, that the courts must now uphold, because it's foundational law. In order for a man or woman to have access to the inherent powers of the court, we must prove that the rule of law, not the rules, but the rule of law, was broken. We must prove that the principles of justice, as it pertains to our specific fundamental right and freedom, were not respected. This is the only way to access the inherent powers of the court. The rule of jurisdiction for the courts is that nothing shall be out of the jurisdiction of the superior court. So the superior court is able to take jurisdiction over all matters. If a right exists, whether that right be a civil right or a fundamental human right and freedom, the superior court has the power and jurisdiction to hear it. As a statutory court, the superior court will deal with civil rights, statutory law, enactments and regulations. And again, never the twain shall the two meet. Can't go in there under statutory court and say, I'm a man, a woman, with full human being, with fundamental rights and freedoms, and what you're doing to me is wrong, and explain everything till you're blue in the face. Doesn't have the power. Inherent jurisdiction of the court is there for the administration of justice. So if the right exists, it can be fit in either here or here. And again, the state party always wants to bring you here and say, class of person, class of being, controlled by enactment, owes duty to enactment, and you failed. Now we're going to punish you. Welcome to the law. But the other side of it is, your rights exist, fundamental rights and freedoms, human rights and freedoms, natural law, natural rights, common law rights, they are expressed in the Charter. This is for the administration of justice, for you to claim. Stop them here, bring them into here. Nothing is out of the jurisdiction of the superior court. Right exists, court can hear you. End of story. Then it's just using the proper forms. And what are you seeking to do? You're saying that my charter rights and freedoms have been violated. My constitutional rights and freedoms have been violated. So, go to the Justice Department, go to the Provincial Justice Department websites, go to the forms, and find the ones that are titled Breach against the Charter of Rights and Freedoms, Violation against the Constitution Act of Canada 1982. And that's the form to use. The Tax Court of Canada, when you look into the enactment, it is declared that it is a superior court of record, as indicated in the statutory instrument which governs this court. Tax Court of Canada enactment, Tax Court of Canada continued. The Tax Court of Canada is continued under the name of the Tax Court of Canada as a superior court of record. As a superior court of record, the tax court operates under two different jurisdictions. The court can operate as a statutory court, statutory creature, strictly enforcing obligations to the enactments. This is the ground that the Crown would want you to stand under and defend yourself. The court, however, also possesses inherent jurisdiction, which can enforce our full legal capacity, and this is the side of the court that an individual is seeking to stand upon. So when they created the Tax Court of Canada, they made it a superior court of record. Now we understand that when we read this statement, the Tax Court of Canada, this is talking about the body corporate. This is not talking about a geographical location, but the body corporate. And this superior court now can operate in two fashions. It can operate as a statutory court only, enforcing statutory rules and obligations on statutory creatures, such as the taxpayer, or under its inherent jurisdiction, it can issue a judgment for the administration of justice. The court, well, not really the court, but those who are operating on behalf of the Crown, is trying to trick you and keep you under its statutory control. This is the mechanism of law that they have to control you and restrict your actions. It is the only mechanism that they possess or can use. The income tax enactment is seeking to render us a class of person, designated an officer of Canada, operating in an office of Canada. The enactment produces the obligation, makes you the statutory creature, and the court is a statutory court. It's there to enforce the enactment against you. It's going to designate you as a class of person, statutory creature, who owes the obligation. And therefore, when you're before the court, it will seek to operate only its statutory powers. And remember,
that if the court is operating its statutory powers, then it cannot access inherent jurisdiction. If you agree and identify yourself as that class of person, then the court will remain a statutory court and it will not recognize your fundamental rights and freedoms. It can't, in most cases. Now, specifically for tax court, if you're going there, there's a specific form that you can use to access the inherent jurisdiction of that court under a constitutional challenge. So a statutory court cannot operate inherent jurisdiction. We must access the inherent jurisdiction, which grants the court the ability to deal with the administration of justice. What an individual must do then is move the court out of statutory control and back into its inherent common law jurisdiction. The side of the court is what deals with common law violations and trespasses against our fundamental rights and freedoms. Now again, remember in Scarola versus Minister of National Revenue, Article 27, the term inherent jurisdiction is one that is commonly and not always accurately used when arguments are made with respect to the jurisdictional basis upon which a court is asked to make a particular order. So we're the ones asking, we're the ones claiming the jurisdiction, and we're seeking for an order. The inherent jurisdiction of a superior court is derived not from any statute or rule of law, but from the very nature of the court as a superior court. And again, in Macmillan Bodell Limited versus Simpson, the superior courts of common law have exercised the power which has come to be called inherent jurisdiction from the earliest times. Inherent jurisdiction of the court does not flow from enactments or from rules of law, but is the core part of the court. The inherent jurisdiction is what common law courts operate, and we know that now common law finds its expression in the Charter and in the international law. Again, respect to the jurisdictional basis, common law, human rights and fundamental freedoms, upon which a court is asked to make a particular order. Scarola versus the Minister of National Revenue, remember, the court as a statutory creature or creation does not have the inherent jurisdiction. So if you're in there as a statutory creature, you can't access the inherent jurisdiction. You cannot seek the administration of justice. Long before you go to court, you have to prepare yourself. And I've covered this already in some of my videos that's on YouTube. The inherent powers of the court are where the administration of justice lies, upholding fundamental rights and freedoms, upholding common law rights. This is the side of the court that must be accessed in order to enforce a charter right and freedom. Jurisdictional basis. What reason are you there for? Are you there for a statutory problem? Are you a class of person? Are you there because the Crown brought you in and you're going to stay in that capacity? Well, then you will not access inherent jurisdiction. Are you there because you're claiming that there's been a common law breach? A charter right and freedom has been limited or abridged? This will bring forth the inherent jurisdiction of the court and will grant the power to the court that they can deal with the issue. Giving you one example here using the Tax Court of Canada. So we look into the enactment that governs the Tax Court of Canada, and what do we find? It states that the Tax Court of Canada is a superior court of record. All right, if you don't have understanding and knowledge about what that's telling you, then you just say, well, it's a superior court of record. Well, what do we know that that's telling us? Great, you're a superior court of record, Tax Court of Canada, so that means you are a statutory court. You could operate solely as a statutory court, and if you're there operating as a statutory court, then you're dealing with officers who are operating in an office of Canada. You are there dealing with residents, people doing business in the corporate body of Canada. You are claiming that they are taxpayers and that they are receiving public money and therefore they will be taxed. We also understand that since it's a superior court, that it also can operate under the inherent power. It has the historic power, it has the jurisdiction. So if there's a right that exists, it can either go here or here. They're claiming that you as a taxpayer have a right, and here we go, right and duty, into statutory. But as a man or a woman, you do have rights, and you can bring them here. And say, I'm seeking the administration of justice.
I'm seeking to enforce my fundamental rights and freedoms, my human rights and freedoms. Now, I believe that the money that I make and the wealth that I create with my energy, my hands, my understanding, my knowledge, and my power, and my will, belongs to me and me alone. And I decide what I do with it, not you. And they are claiming through an enactment and a regulation, and I'm not walking through the whole principles of justice right now, but they're claiming through enactment and a regulation that indeed I am an officer operating in an office of Canada, I'm resident in Canada, I'm using public money, and I must make a contribution for the good of society. I must make a contribution for the benefit of mutual society. But I believe and I see in international law, under common law rights, under human rights and fundamental freedoms, I have another right, I have another freedom that I can express. And the legislators of Canada and the ones who are making these laws up here in Canada are not allowing me to express that right and freedom. They're limiting and abridging that right and freedom. So if we did not have that right and freedom operating here in Canada, if we did not have the ability to decide if we will contribute to a society based upon the principle of mutual benefit, why would you make the Tax Court of Canada a superior court of record? Why wouldn't you just make the Tax Court of Canada a statutory power and done with it? Because the legislators and the ones who've created all this system around us, they know the obligations, or they knew, I should say, the obligations. And when it came time to create the Tax Court of Canada, they said, well, we understand that there's the administration of justice concerning our fundamental rights and freedoms, and there has to be an avenue, a mechanism available for individuals to operate it. So this way we're going to make the Tax Court Superior Court. It's a statutory court and inherent power. If anybody ever comes in with a right claiming that they've been violated, well, the court will have the power to hear it. And if when we call them in and they don't understand what's going on and they stay in the statutory power, well then great, we've got them. We'll walk out with a nice instrument of judgment against them, saying you owe a whole bunch of money to the CRA, to Her Majesty's agent, because of the fact that you're part of that corporate body of Canada. So you see what's going on. In the court systems that are in operation in Canada, there's two jurisdictions. You can operate from the statutory side, where you lose, or you can get into the inherent powers, which they don't like, but they have to produce the remedy on your behalf, because it's their obligation. And our fundamental rights and freedoms, they existed long before the creation of Canada. They existed long before the statutory powers, the taxations, and all this. And we have the right to stand upon them if we understand how to use them.